100 words per minute. Get ready. Start. The facts giving rise to this appeal by the plaintiff are these. Stop. Bhaiya Rudra Pratap Dev, the original plaintiff, was the holder of an impartible estate known as Nagar Puntari estate in the district of Pakamau, the succession to which used to be governed by the rule of lineal primogeniture, the junior members of the family being entitled to corpus or maintenance grants, subject to payment of quite rent and also to resumption on extinction ought any high in the male line stop. The estate was in charge of officials under the Chota Nagpur Encumbered Estates Act from March 1932 until it was released in October 1945. The estates vested in the state of Bihar under the Bihar Land Reforms Act, 1950, in pursuance of a notification dated 5/11/1951, although on account of some litigation it came into the possession of the state government sometime later. Stop. Para. The father of the defendant, respondent number 1, was the younger brother of Rudra Pratap Dev and he had been given some maintenance grant. Rudra Pratap transferred his interest in 8 villages as maintenance grant to the defendant under an unstamped and unregistered document dated 14/4/1952. It included 8 villages, including villages Sigsigi and Patihari. Stop. But the case of Rudra Pratap was that the last named 2 villages were fraudulently included in the document by the defendant by bringing his within bracket plaintiffs bracket close employees in collusion with him within bracket defendant bracket close. The state of Bihar did not, however, recognize this grant in respect of any of these 8 villages on the basis of an inquiry under section 4 within bracket small h bracket close of the 1950 Act and in view of the provisions of section 12A of the Chota Nagpur Encumbered Estates Act, according to which the holder of an estate cannot, even after release from the purview of the act, alienate any property appertaining to the estate without the previous sanction of the divisional commissioner. Stop. Para. Subsequently, there was a dispute between Rudra Pratap and the defendant regarding the possession of 170.53 acres of land appertaining to village Siksigi, giving rise to a proceeding under section 144 of the Criminal Procedure Code, which was converted into one under section 145, which was decided against the plaintiffs on 4/7/1955 and possession of the defendant or the suit land was accepted. Stop. Hence, the suit was instituted on 9/7/1955 by Rudra Pratap for recovery of possession of this area with masony profits. Stop. The original plaintiff died in September 1957 and his 2 sons and 4 widows within bracket of whom the first son is the appellant and the others are respondents here bracket close were substituted in his place as plaintiffs. Stop. It may be also stated that the Hindu Succession Act, 1956 came into force on the 17th June, 1956, and impartible estate were abolished by this act. Stop. Para. Both the courts decided the suit against the plaintiffs. Their findings are stopped. Para. Bheta Rudra Pratap Dev had given his interest in the eight villages, including Sigi and Patihari in Khorpos, and in proof thereof executed the document dated 14 for 1952 in favor of the defendant. Stop. Para. The grant of this corpus by Rudra Pratap Dev after the release of his estate from the management under the Encumbered Estates Act without the sanction of the commissioner was void under section 12A if the act, and it was also void on the ground that after the vesting of the estate in the state of Bihar under the Land Reforms Act, Rudra Pratap had became Rayyat of the cultivated land under section 6 of the latter act 9, and such Rayyati right could not be transferred without a registered document on account of certain provisions of the Chota Nagpur Tenancy Act. Stop. Para. The defendant was in possession of the suit land as a corposdar, not as a trespasser, and therefore, not liable to be evicted on this ground alone. Stop. Para. The Nagaruntari estate was an ancestral impartible estate in the hands of Rudra Pratap, governed by the rule of lineal primogeniture. Stop. Custom of impartiality of the estate did not survive after the commencement of the Hindu Succession Act, 1950, and the court can take notice of the change in law during the pendency of the litigation within bracket 6 bracket close. The Nagaruntari estate became, after the commencement of the Act of 1956, an ordinary family joint property of the parties, and, therefore, after the death of Rudra Pratap. Stop. Rudra Pratap, only his interest, not the entire estate, would pass to his sons and widows, and, therefore, the defendant was in possession of the suit property as a co-sharer. Stop. Para. Findings numbers within bracket 1 bracket close, within bracket 2 bracket close, within bracket 4 bracket close, and within bracket 5 bracket close were not challenged by either party for the purpose of this appeal. Stop. It was also considered by counsel for both the parties that the right, which Rudra Pratap had acquired under the rule of primogeniture, within bracket primogeniture, came into existence when his father died, and that right remained unaffected until his death in September, 1957, in spite of the coming into force of the Act of 1956 on 17/6 1956, because numbers 4 and 5 thereof merely destroy the custom of impartiality but do not support to affect the existing rights, the language of the sections being expressly prospective. Stop. Para. It would be convenient, first of all, to examine the incidents of the ancestral impartible estate in the hands of Bhaiya Rudra Pratap Dev. Stop. The law appears to be settled by the decisions of the Privy Council and the Supreme Court. Stop. In Rani Sartaj Kumari versus Rani Devrai Kauri, 15, second appeal 51, within bracket PC bracket close, a gift by the holder of an ancestral impartible estate in favor of the holder's junior Rani was challenged on behalf of his Minoi son through the senior Rani, and it was held to be valid. Stop. Their lordships said. Stop.